In this installment of Washington Legal Foundation's Legally Brief, the third in a series of videos concerning the Google book scanning legal settlement, Hadrian Katz, a partner with the law firm Arnold & Porter, will express the concerns his client, the Internet Archive, have with the settlement agreement as it currently stands.
As counsel for the Internet Archive, which is the sponsor of the very useful and very popular Wayback Machine, we oppose the Google settlement. And frankly, we're somewhat skeptical that any acceptable settlement can be negotiated for that case. That's because the kind of arrangement that Google and the author and publisher plaintiffs appear to have in mind really is fundamentally inconsistent with the way class actions are intended to operate. Class litigation was designed to streamline dispute resolution by adjudicating one typical case and extending the results of that case to similarly situated prospective litigants. Here, there's been no adjudication of anything, and it's anyone's guess whether or not there are any other prospective litigants, and if there are, whether they're similarly situated. Class litigation is not designed to be a substitute for the legislative process. It's not designed to make rules and to distribute rights. And that seems to be what the parties in the Google case have been trying to do. The Google litigation began with a complaint filed by the Authors Guild against Google's unauthorized copying of essentially all of the books in the University of Michigan library. The plaintiffs sought damages for copyright infringement and an injunction against future copyright infringement. That's an appropriate class action. But under the class litigation rules, there must be common questions of law and fact. The claims of the plaintiffs must be typical of those of all class members. Class counsel must adequately represent the entire class. Common questions must predominate over any individual questions, and all class members must receive individual notice of the settlement. But the settlement agreement in the Google case was structured simply and primarily to grant Google broad rights to copy, utilize, and distribute in the future millions of orphan works. And by orphan works, I mean published books where the copyrights belong to unknown and unidentifiable owners. These orphan rights owners would likely constitute a large majority of the proposed settlement class in the Google case. But it's difficult to see how that sort of class could possibly meet any of the legal requirements for class action. There simply is no practical way to notify all of these orphan rights owners, many of whom children, heirs, creditors of deceased authors may be unaware that they are rights owners. There's no practical way to notify all of them of the impact of the settlement upon them. And it's impossible to know if the ostensible class representatives, these plaintiffs who've been participating in the litigation, are typical of the entire class, because it's impossible to know what the orphan rights owners would want and what they would perceive to be in their interest. Some may be delighted to have Google use and distribute their works. Others may be appalled at the commercial exploitation of works that the author's heirs might not want distributed or viewed by anyone. Others might want to grant exclusive rights to the highest bidder or to the most sympathetic nonprofit cause or to someone else. There's no way that the ostensible class representatives can adequately represent the orphan rights owners' interests, as no one can really know what those interests are. This is simply not the kind of result that's obtainable under the class action rules. We believe that if there's to be any settlement in the Google case, it should be limited to the plaintiffs themselves and to any rights owners that affirmatively elect to participate.